The pen was cold. That's the detail I still remember. Not the fluorescent lights humming above Cook County Circuit Court, not the smell of old carpet and recycled air, not even the sound of Marcus shifting in his chair 3 feet to my left. Just the pen. Cold, heavy, and slightly too formal for what I was being asked to do with it. I signed my name on line 14 of a document I had already read 4 times. And Margaret Hale, my mother-in-law of 6 years, laughed. Not a cough. Not a polite smile behind her hand. Laugh. Quiet enough that only her attorney heard it, but I was sitting close enough to watch her shoulders shake. She had waited a long time for that moment. What she didn't know, what none of them knew, was that I had been waiting longer. My name is Claire Donovan. I'm 34 years old, and for the last 9 years I have worked as a senior contracts analyst for a logistics firm headquartered in the West Loop. My job, in plain terms, is to read documents that other people don't want to read, find the language that doesn't belong, and flag it before it becomes someone else's expensive problem. I am very good at my job. I make $94,000 a year. I have made slightly more every year since I was 26. I do not say that to impress anyone. I say it because it matters to this story. Because the money I earned is what bought the house, and the house is what Margaret spent 4 years trying to take. I met Marcus Hale at a friend's birthday dinner in the spring of 2016. He was funny. He was warm. He asked good questions and actually listened to the answers, which at 26 felt rarer than it should have. We dated for 2 years, got engaged in Lisbon on a trip I half-planned and fully paid for, and married in September 2018 at a venue in Andersonville that cost $23,000. I paid for $14,000 of that. I mention that not with bitterness but with precision, because precision is how I survived what came next. In March of 2019, Marcus and I bought a house in Evanston. 3 bedrooms, 2 bathrooms, a yard with a dying oak tree that I was convinced I could save with enough attention and the right soil. Purchase price: $387,000. I contributed $54,000 of the $78,000 down payment. My name was on the deed. My credit score made the mortgage possible. I painted the living room myself over a long weekend in April. Sage green. 2 coats. I planted roses along the south fence in May. By June, I had started thinking quietly about the 3rd bedroom, what color it might be, what it might become. That summer, Margaret Hale began stopping by unannounced. First it was twice a week. Then it was 4 times. Then she had a key, which I did not give her, and which Marcus admitted to copying without asking, and she would let herself in on Saturday mornings before we were awake, start coffee in my kitchen, and be sitting at my dining table by the time I came downstairs. I told Marcus it made me uncomfortable. He told me she meant well. That was the first time I understood what kind of marriage I was actually in. Margaret Hale is 61 years old, a retired school administrator, and one of the most methodical people I have ever encountered. She does not rage. She does not throw things. She does not send unhinged text messages at midnight that you can screenshot and show someone. She operates in suggestion, in implication, in the soft, patient erosion of your credibility inside your own home. And she started on me before the paint in the living room was even dry. The first example I will give you is small. They always start small. It was Thanksgiving 2019, our first holiday in the new house. I had spent 2 days cooking. Rosemary roasted turkey, homemade stock, a sweet potato gratin from a recipe I had been holding onto since culinary school, which I attended for 1 semester at 22 before deciding it wasn't the path. 11 people around my dining table. My table in my house. Food I had planned and purchased and prepared almost entirely alone because Marcus worked late on Wednesdays and Thanksgiving that year fell on a Thursday. Margaret arrived 40 minutes early, walked into my kitchen without asking, lifted the lid on every pot, and then turned to Marcus, not to me, to Marcus, and said, "Sweetheart, I could have brought food. You should have told me she was doing all of this herself." She said it like I wasn't standing 2 feet away holding a basting brush. She said it like all of this was a problem I had created rather than a meal I had made with my own hands in my own home. Marcus laughed. Not meanly. Just reflexively. The way people laugh when they don't know what else to do. And Margaret moved on, set her casserole dish on the counter next to my gratin, and began telling my sister-in-law about a new development in Wilmette. I stood there holding the basting brush and understood something clearly for the first time. Margaret did not see me as the woman who lived in this house. She saw me as a temporary feature of her son's life. And she was going to behave accordingly until proven otherwise. The second example is less small. In the summer of 2020, Marcus and I began talking about starting a family. It was a quiet, careful conversation. The kind you have in bed at 11 at night when the rest of the world has gone still. We weren't rushing. We were just opening the door. Somehow, within 2 weeks, Margaret knew. And within 3 weeks, she had told Marcus. Not both of us, just Marcus, during one of their daily phone calls that I was not invited to participate in, that she had concerns. That I seemed career-focused in a way that might make the transition hard. That she had read an article about women who waited too long and perhaps we should think carefully. I was 30 years old. Marcus relayed this to me gently, carefully, in the way he relayed everything his mother said, wrapped in so much cushioning that it took me a moment to understand I was being insulted. I told him that his mother's opinion about my reproductive timeline was not something I was interested in discussing. He said she was just worried. I went for a very long walk. The third example is the one that still sits in my chest when I let myself think about it. In February of 2022, 4 months before Marcus asked me for a divorce, Margaret hosted her annual birthday dinner at her home in Wilmette. Every year the same ritual. 14 people, catered Italian, her good china, a slideshow she made herself of the past year's family moments. That year's slideshow was 43 slides. I appeared in 2 of them, both in the background, both partially obscured. Marcus's previous girlfriend, a woman he had dated for 8 months in 2014, 3 years before we met, appeared in 4 slides. Margaret had included throwback photos from a family trip to Michigan. Photos from a life I had never been part of. When I caught Marcus's eye across the table, he looked away. I drove home alone that night because I said I had a headache. I sat in the driveway of our house in Evanston for 11 minutes before I could make myself go inside. That was the night I stopped trying to be understood. That was the night I started paying attention to everything else. The dinner was Marcus's idea. That should have been my first warning. Marcus does not plan dinners. Marcus does not make reservations, does not coordinate schedules, does not send calendar invites with restaurant addresses and parking notes attached. In 6 years of marriage I had organized every vacation, every holiday gathering, every birthday dinner for his side of the family including his mother's, including the one where she erased me from her slideshow. So when he texted me on a Tuesday afternoon in April of 2022 and said, "Can we do dinner Saturday? Just the 4 of us. Mom wants to talk about some things." I felt something shift in my stomach before I even finished reading the message. Just the 4 of us meant Marcus, Margaret, her attorney Gerald Foss, who had been Margaret's personal lawyer for 20 years and who I had met exactly twice at family functions where he drank scotch and said very little, and me. Not a family dinner. Meeting. Said yes. I wore the gray blazer I wear to depositions. We met at a restaurant in Lincoln Park. White tablecloths. Bread service. The kind of place where the noise level is low enough that everyone at neighboring tables can hear exactly what you're saying if they choose to. Marcus ordered wine. Gerald ordered sparkling water. Margaret ordered nothing and placed her hands flat on the table in a way that I recognized immediately as deliberate. She had done her own version of preparing. We made 11 minutes of small talk. I know because I watched the clock above the bar. Then Marcus reached into the interior pocket of his jacket and slid a document across the table toward me. Folded. Tri-folded, the way you fold something to fit in an envelope. We think it's time to talk about the house, he said. I did not touch the document. I looked at him. What about it? Margaret spoke before he could answer. Claire, she said, and the way she said my name, measured, almost gentle, like she was addressing a student who had repeatedly missed the point, made my jaw tighten. Marcus has worked very hard. He's contributed to that home. He has a right to what's his. He's on the mortgage, I said. I'm aware. Gerald has prepared something, she continued, as if I hadn't spoken. A proposed agreement. We think it's fair. More than fair, honestly, given. He paused. Looked at Marcus. Something passed between them. Given the circumstances, she finished. I picked up the document. It was a voluntary property transfer agreement. Prepared, signed by Gerald as witness, and dated 4 days earlier. It proposed that I relinquish my ownership stake in the Evanston property in exchange for a cash settlement of $31,000. The house had been appraised 8 months prior at $463,000. My down payment contribution alone had been $54,000. I read the document twice. Both sides. Every clause. The table was quiet while I did this. I could hear Margaret breathing. When I finished, I folded it back along its original creases and set it next to my bread plate. You had this drawn up 4 days ago, I said. We wanted to be prepared, Gerald said. For what? Nobody answered. Marcus. I looked at my husband directly. Did you read this before you brought it here? He had the grace to look uncomfortable. Claire, it's a starting point. It's not a starting point, I said. My voice was completely level. I want to be clear about that. I did not raise it. I did not cry. I did not give Margaret Hale the satisfaction of watching me come apart in a white tablecloth restaurant in Lincoln Park. A starting point is a conversation. This is a document with a witness signature and a date. This is not a starting point. Margaret set her hands on the table again. You've always made things harder than they need to be, she said. That's been the pattern, Claire. From the beginning. Everything is a negotiation with you. Everything is a contract. She said the word contract the way some people say a curse word. Marcus needs to move forward. We are trying to make this easy for you. The least you could do. Margaret. Stop. I'm going to need you to not finish that sentence, I said. The table went very quiet. I put the document in my bag, picked up my water glass and took a long sip. Then I set it down carefully. Then I stood up, buttoned my blazer, and looked at all 3 of them in turn. I'll have my attorney reach out to Gerald by end of week, I said. Thank you for dinner. I walked out. Past the host's stand, through the heavy front door, out onto the sidewalk where the April air hit my face like a reset button. I sat in my car for 4 minutes. Then I called my attorney, Patricia Wang, family law specialist, 15 years of experience, the kind of woman who picks up on the second ring even at 9 p.m. on a Saturday, and I told her everything. She listened without interrupting. When I finished, she said, Claire, do you still have the original deed packet from closing? Yes, I said. All of it. Including the trust addendum. I went very still. What trust addendum? He paused. Go home, Patricia said. Pull everything. Call me back in an hour. I keep my closing documents in a fireproof lockbox under the built-in shelving in the second bedroom. Gray metal. Combination lock. The kind of box that most people buy with good intentions and then forget the combination to within 18 months. I have never forgotten the combination. I pulled it out at 9:47 p.m., sat down on the floor with my back against the bed, and opened it. The deed packet from our 2019 closing was held together with a binder clip and organized in chronological order, the way I organize everything. Purchase agreement on top. Inspection report. Title commitment. Mortgage note. Closing disclosure. And at the very back, behind a sheet I had always assumed was a standard Illinois disclosure form. A 7-page document I had apparently signed at closing without fully processing, because we had been on page 40-something of a closing packet and the notary was moving briskly and Marcus was already standing up to shake hands. A trust addendum. I read it once fast. Then I read it again slowly. Then I called Patricia. "Tell me what you're looking at," she said. I read her the title. Revocable Living Trust Co-Ownership Addendum. Executed pursuant to 760-3, Illinois Trust Code. She exhaled slowly. "Okay. Keep reading." The addendum had been prepared by the title company. Not by our real estate attorney. Not by Margaret's Gerald. As a standard protective instrument on jointly owned properties where one party contributes disproportionately to the down payment. Our real estate agent, a meticulous woman named Sandra Park, who I had chosen specifically because of her reviews, had quietly recommended it at our final walkthrough meeting. I had signed it. Marcus had signed it. It had been notarized, recorded with Cook County, and filed. And then apparently both of us had forgotten it existed. The relevant clause, the one Patricia asked me to read aloud twice, established that the property was held in a revocable living trust with me named as sole trustee. Marcus was listed as a beneficiary, not a co-trustee. The distinction, Patricia explained, was not subtle. As sole trustee, I controlled the disposition of the trust asset, meaning the house, entirely. Marcus could not transfer, sell, or legally compel the sale of the property without my written consent as trustee. Furthermore, and this was the clause that made me sit very still on the floor of the second bedroom at 10:15 on a Saturday night, any attempt to dissolve the trust or challenge the trustee designation triggered a mandatory 90-day independent financial audit of all trust assets, conducted by a court-appointed examiner, at the expense of the challenging party. "Patricia," I said carefully, "does Gerald Foss know about this?" "Given that he prepared that transfer agreement," she said. "I would guess not." I looked at the document in my hands. 7 pages. My signature on page 6. Marcus's on page 7. Notarized in blue ink. "What does this mean for the proceedings?" "Yes. It means," Patricia said, "that the voluntary transfer agreement they presented you tonight is legally unenforceable as written. You cannot voluntarily transfer a trust asset without trustee authorization, which is you authorizing yourself, which changes the entire structure of any agreement they could propose. And if they push it into divorce court, then we bring Exhibit B." She said it simply, not triumphantly. Just as a fact, the way I might tell a client that a clause they'd overlooked had changed the shape of their contract entirely. Which is exactly what had happened. I put the document back in the lockbox, closed it, sat on the floor for another few minutes in the quiet of the second bedroom, the one I had once thought about painting a soft yellow, for a future that didn't arrive the way I'd imagined. Then I stood up, went to the kitchen, made myself a cup of tea, and began making a list. Everything I needed to pull together. Every document. Every bank statement showing my down payment contribution. Every receipt from the renovation work I had managed and largely funded. Every text message from Margaret that I had screenshot over 4 years of quietly documenting what I knew, even then, might someday matter. I am a contracts analyst. I read what other people don't. And what I had just found, sitting in a fireproof box under a shelf in a house that Margaret Hale thought she had already won, was the entire case. I want to be precise about what I did not do. I did not call Marcus that night. I did not forward him the addendum with a pointed message attached. I did not post anything. I did not tell my mother, my closest friend Dana, or my colleague Reshma, who had watched me hold myself together through 2 years of a quietly dissolving marriage and deserved to know. I told no one. I made my list. I drank my tea. I went to bed. The discipline of that night is something I am still quietly proud of. Monday morning I was at Patricia's office by 8:30 with a lockbox, a flash drive containing 4 years of screenshots organized by date and category, and a manila folder with every financial record related to the Evanston property going back to the original purchase. Patricia reviewed everything over the course of 2 hours while I sat across from her and answered questions. At 10:45 she looked up from the trust addendum and said, "Claire, I want you to understand something. They are going to file. Marcus is going to file for divorce and petition for equitable distribution of the marital home. Gerald is going to argue that the trust addendum is a technicality and that the spirit of the co-ownership was equal partnership." "I know," I said. "And we are going to let them," she said. "We are going to respond to every filing on time, without aggression, without tipping our hand. We are going to appear cooperative. And we are going to wait until the final hearing to introduce the trust addendum as Exhibit B." He nodded. "Margaret," Patricia continued, "based on what you've described, is going to assume this is already won. She is going to encourage Marcus to push forward quickly. She may even attend proceedings." "She will," I said. "I was certain of that." "Good," Patricia said. And left it there. Over the following 11 weeks, I did exactly what Patricia instructed. I responded to Gerald's communications through Patricia, promptly and without hostility. When Marcus's team requested a property appraisal, I scheduled it within the week and made myself available. When they requested financial disclosures, I submitted them completely, including every record of my down payment contribution, every renovation receipt, every mortgage statement showing my payment history. I gave them everything they asked for. I gave them everything except the one document that changed what all of it meant. In week 4, Marcus called me directly for the first time since the Lincoln Park dinner. He wanted to know if we could talk without lawyers. I told him gently that I didn't think that was a good idea given where things stood, and that Patricia was the right point of contact. He sounded frustrated, possibly confused. I did not explain further. In week 7, Gerald sent a letter to Patricia suggesting that given the uncomplicated nature of the asset in question, both parties might consider an expedited settlement to avoid prolonged proceedings. He proposed a revised cash offer of $47,500. Patricia responded that her client was prepared to proceed to a final hearing. Gerald sent a follow-up suggesting $55,000. Patricia responded the same way. I imagine that confused him. In week 9, I drove past the house in Evanston on a Sunday afternoon. Not to stop, just to look. The roses along the south fence were coming in. Someone, me the previous fall, had cut them back properly for the first time since we'd planted them, and they had rewarded that attention. 3 of the 5 bushes were blooming ahead of schedule. I thought about the version of myself that had planted them. 29 years old, new house. A marriage that still felt like something worth building. I didn't feel sorry for her exactly. She had made careful choices even then. She just hadn't known yet which ones would save her. Kept driving. The final hearing was scheduled for a Thursday in March. Patricia told me to arrive at the courthouse 15 minutes early, dress professionally, and bring the lockbox. I wore the gray blazer again. The same one from the Lincoln Park dinner. Marcus and Gerald arrived together. Margaret arrived 3 minutes later in a camel coat I had never seen before, which told me she had gone shopping for the occasion. She sat in the gallery behind Marcus's table with her hands in her lap, and the expression of someone attending an event whose outcome she considered settled. She did not look at me when I walked in. She did not look at Patricia. She did not look at the gray accordion folder Patricia set on our table, which contained, behind 31 other documents in careful order, a single 7-page trust addendum with a Cook County recording stamp dated March 14, 2019. She had no reason to look. She thought she already knew how the story ended. The hearing was scheduled for 9 a.m. Judge Carol Renata, 53 years old, 21 years on the Cook County bench, the kind of judge who reads every page of every document before she enters the room, called the session to order at 9:04. Gerald presented first. He was polished, organized, and entirely confident. He walked through the marital asset framework, cited Illinois equitable distribution statutes, referenced the appraisal, and proposed a settlement structure that awarded Marcus 60% of the property's current value, $463,000 appraised, meaning Marcus's proposed share landed at $277,800, with a buyout timeline of 90 days. He spoke for 14 minutes. He never mentioned the trust addendum, because he didn't know it existed. Patricia presented second. She was quieter than Gerald. She always is. She laid out my financial contribution to the property, the $54,000 down payment, the $31,000 in documented renovation expenses I had managed and paid for over 3 years, the mortgage payment history showing 37 of 48 payments made primarily from my account. Then she said, "Your Honor, before we proceed to distribution, I'd like to introduce a recorded instrument that materially affects the court's jurisdiction over this asset." Gerald looked up. Patricia placed Exhibit B on the bench. Judge Renata took it. "Read the title." Turn to page 2. Then page 3. The courtroom was quiet in the particular way that courtrooms go quiet when something has changed and not everyone in the room has caught up yet. Margaret had caught up. I watched her from my peripheral vision without turning my head. I saw the moment she understood. Not the legal specifics but the shape of it. The fact that Patricia had something. The fact that Gerald had gone very still. The fact that Marcus had leaned over to whisper to his attorney and Gerald had not whispered back. Judge Renata looked up from the document. "Mr. Foss," she said, "were you aware of this instrument at the time you prepared the voluntary transfer agreement presented to Mrs. Donovan in April?" A pause that lasted approximately 3 seconds and felt considerably longer. "I was not, Your Honor," Gerald said. "Were you aware of it when you filed the petition for equitable distribution?" "I was not." The judge looked at the document again. Then at Patricia. Then at me. "The property in question," she said carefully, "is held in a revocable living trust with the petitioner's spouse named as sole trustee. Equitable distribution proceedings cannot compel the transfer of a trust asset without trustee authorization under Illinois Trust Code 760-3. This court does not have jurisdiction to distribute this asset as proposed." She set the document down. "Mr. Foss, I'd recommend your client seek a revised legal strategy. This petition as filed cannot proceed." Gerald requested a recess. It was granted. 20 minutes. I sat at the table with Patricia and drank water from a paper cup and did not look at the gallery. When the session resumed, Gerald requested additional time to review the trust instrument and file a supplemental motion. Judge Renata granted 30 days. Those 30 days became 60, then 90. Gerald filed a motion to challenge the trust designation. Patricia responded with the full recording history from Cook County. The challenge was denied. 4 months after that Thursday hearing, Marcus's legal team proposed a new settlement. One that reflected my actual contribution. One that covered my attorney's fees. One that left the house and the trust intact and solely under my authority until I chose otherwise. I signed that agreement on a Tuesday morning in July. Margaret's name appeared once in the public court record from the March hearing, in the gallery attendance log, which is a matter of public record in Cook County. Small thing, but a permanent one. She had walked into that courtroom as the woman who had orchestrated everything. She walked out as a footnote. The roses were in full bloom by the time I drove back to Evanston that afternoon. All 5 bushes. Red and full and completely indifferent to everything that had happened that winter. I stood in the backyard for a long time. I didn't cry. I didn't call anyone. I just stood there and let it be over.